Можемо починати.
So, hello everyone. International Law Committee of Ukrainian Bar Association is delighted to start this event on a really interesting and up-to-date topic. Today, my name is Olga Kuchmienko, and I am deputy head of the International Law Committee of Ukrainian Bar Association, and I highly appreciate the chance to represent our topic and our notable speakers. Today we will talk about notifications under Article 15 on the Convention in the context of the COVID-19 pandemic, international discussions and lessons for Ukraine. As in these hectic times, the idea to hold an event for this topic appeared after posts of Mykola Gnatovskyy on Facebook, which Anna, the head of our committee, and I have read, and then we shall held an event about that. And then Andrea, who is from Serbia, and Ilze, who is from Latvia, kindly agreed to bring us up to date on what is going on in other countries in terms of that. So the idea was connected with Article 15 of the European Convention on Human Rights, and the idea of the Article 15 is that in time of war or other public emergencies threatening the life of the nation or of any high contracting party, the state may take measures derogating from its obligations under this convention to the extent strictly required by the situation. And some of countries, 10 countries actually, 10 parties of the convention have already notified of their intention to derogate on derogations from certain provisions of the convention, and Serbia and Latvia were out of them. So today we will listen to presentations, and any questions, comments are more than welcome in the chat. The discussion will be held by Mykola Gnatovskyy, the president of the European Committee of the Prevention of Torture, first vice-president of Ukrainian Association of International Law, who is representing Ukraine in this discussion. Andrea Nikolić, who is consultant at Ministry of Justice of Republic of Serbia. She is she teaching at the University of Belgrade, and also she is an ambassador for Serbia and Montenegro at Arbitrator Intelligence. And our last but not the least speaker is Ilze Dubava. She's lawyer at the State Chancellery of the Republic of Latvia. Both Ilze and Andrea are speaking of their private capacity. And our committee and the Ukrainian lawyers community highly appreciate and are thankful to all speakers for joining us. So let's start. Mykola Gnatovskyy, please, the floor is yours.
Thank you very much, Olga, and good afternoon, or already good evening in Ukraine to everyone. And also in Riga, I guess it's also after 6 now, and it's a pleasure to be with you today. And it was actually very interesting to hear now from Olga that my Facebook posts inspired this discussion. That's rather amusing, and thank you very much for your attention to the posts. And in fact, the situation related to COVID-19, or rather to the so-called sanitary crisis caused by COVID-19. This is the terminology which is widely accepted now within the Council of Europe area, and actually by the Council of Europe. That is a topic that is certainly most important or most interesting for all of us from various standpoints. Of course, the life of everyone has been significantly affected by COVID-19, and or rather, and let's be open about it, more than by COVID-19 per se, in most cases by the measures taken by the authorities of various European countries and also other countries in the world to contain the spread of the virus and to protect the population. So essentially, the topic is of course very much alive, and unfortunately we are still not in the post-COVID situation. We are still in the middle of it, unfortunately, and therefore the topic will remain interesting. However, of course, this topic raises lots of human rights related concerns, and as such is a major challenge to human rights, to rule of law and democracy. In various respects, and one can of course go for hours simply enumerating the issues that have been raised by COVID in terms of human rights or in terms of democracy and rule of law. And it is also a huge test to the societies as such, because the current crisis has already put to test the way the societies are functioning. Is there a functioning healthcare? Is there solidarity among members of the society? Is there a sense of sort of common responsibility for the life of everyone? And let's say things such as simply the operation of businesses or the work of people, whether it is teleworking or not. This has also created really numerous issues and numerous challenges. The topic, as I understand it, for today's exercise is more limited. It is essentially a topic that deals with the European Convention on Human Rights, and more specifically with the use of the derogation clause that exists in the Convention of Article 15, as Olga has mentioned, by 10 Council of Europe member states, which includes Latvia and Serbia, and therefore it is so good to have Andrea and Ilse with us today, because they know sort of from the first hand the logic of both the Serbian government and the Latvian government in actually notifying about the derogation, which is in itself an interesting decision. So what I wanted to say is try and simply introduce the general argument whether derogation was necessary and which aspects it concerns. And then, as long as I am among the three key speakers today, I'm the only one coming from Ukraine, I will also briefly introduce the measures that have been taken by Ukraine and the discussion that has taken place in Ukraine, whether a derogation was advisable or not. Because, as you know, Ukraine has not informed the Secretary General of the Council of Europe of any derogation, even though such discussions, and this is not a secret, such discussions have been held in the Ukrainian government and in the Ukrainian parliament. So let me start by discussing the possible sort of provisions of the convention where derogation could be made, or where it was actually made by the states concerned. So it is, of course, not a secret to everyone who has joined this webinar, or to our viewers on YouTube, that human rights that are included into the European Convention on Human Rights and the protocols thereto, they fall under one of the two major categories. They are either derogable or non-derogable rights. So I'm sure lawyers are well aware of the fact that there are certainly non-derogable rights which are quite explicitly mentioned in the text of Article 15 of the European Convention on Human Rights in paragraph 2, where it reads that no derogation from Article 2, which is right to life, except in respect of deaths resulting from lawful acts of war, or from Articles 3, which is the prohibition of torture and other forms of ill treatment, 4, the prohibition of slavery, paragraph 1, and 7, which is which is the article dealing with the rule nullum crimen nulla pena sine lege, so that the principle of legality shall be made under this provision. So we already have a number of so-called non-derogable rights, which actually logically means that the rest are in principle derogable. So which means that everything, all other provisions of the convention could be derogated from if need be, or there could be a notification about an intention of the state concerned to derogate from these articles. And actually, I think this also matters when we are talking about the notification and the notifications made by the 10 states concerned, 10 member states of the Council of Europe, which is alphabetically Albania, Andorra, Armenia, then also alphabetically it's Austria, Azerbaijan, Croatia, Czech Republic, Estonia, Finland, I think it's I'm slightly in the wrong list now. Apologies for this. I have it in here. It's Georgia, Estonia, Armenia, Romania, Latvia, Serbia, of course, and so on. North Macedonia. I think I've now mentioned all the 10 of them. These are notifications which essentially inform the Council of Europe that the state might derogate from the convention. So it doesn't necessarily mean that actually the state will take measures derogating from certain articles mentioned in the notification. And also it is noteworthy that, which is unfortunately the fashion nowadays with derogations, such as, for example, the French or the Turkish derogations from the convention, which were made on different occasions on completely unrelated subjects, that they could be unspecific, because, for example, the derogation that was made by France in respect to the measures taken to fight terrorism was extremely unspecific. The French authorities simply told the Council of Europe that they might derogate from provisions of the convention without actually specifying which exactly. And the suit was followed by the Turkish authorities when they derogated from the convention after the attempted coup d'etat in summer 2016. So essentially, these are sort of very, very generic derogations, and some of the derogations made by the member states of the Council of Europe concerning COVID, they are also not very specific, whereas others are extremely detailed. So there's really a big difference in the approaches taken by various member states of the Council of Europe. So in a nutshell, if these are derogations from the so-called derogable rights, then the question arises, and I think this is the key question for the whole discussion: is it really necessary to make a derogation on the derogable rights, especially when it comes to the provisions of the convention, where the state has a rather wide margin of appreciation as to how to act in a particular situation based on the principles of legality, necessity, and proportionality. So essentially, this is the question for every state concerned and for every lawyer concerned. was it actually a good idea to invoke the derogation clause of the convention? Because, as Olga has already mentioned, Article 15 is also drafted in a very stringent manner, and derogations are only possible as far as they are strictly required by the exigencies of the situation. And also there is an additional requirement that such measures should not be inconsistent with other obligations of the state concerned under international law. So was it really necessary? And this is the whole question, and this is why the discussion among various lawyers, both university professors and practitioners, are so heated on the subject. And we clearly see two trends in these discussions. One is to say that the situation that we are facing with COVID, it is so unprecedented, it is so serious, that it is actually better to say from the outset that the state will be derogating from certain obligations that it has under the European Convention on Human Rights and protocols there too. But of course, this derogation would be subject to the very strict rules that are provided for by Article 15 of the Convention. Or this is one approach, and this is the argument in favor of the derogations. Whereas the other school of thought, so to say, says that the main principle should be the principle of normalcy. And the states should essentially proceed from the assumption that everything is normal, and despite the crisis, despite the pandemic, it is still possible to deal with this in the more or less business as usual mode. Of course, limiting certain rights existing in the European Convention on Human Rights, but invoking essentially the exact reasons for limiting those rights, which are mentioned typically in paragraph 2 of the respective article of the European Convention on Human Rights, like in Article 8, 9, 10, 11. You have, of course, the second paragraph, paragraph 2, which enumerates the situations when it is possible to derogate, to limit the rights, and which introduces the test of legality, necessity, and proportionality of any such measures. And the argument here is that human rights would be better off in the situation when no formal derogation is made, where state authorities should still be guided by the exact provisions of the convention and of the, as interpreted, of course, by the European Court of Human Rights, and that this could also mean that it would be more difficult for those governments which want to abuse the situation to concentrate more powers, sort of to hold them back and to make sure that they are not exaggerating, that they are not trying really to usurp power, because this is exactly the discussion, for example, that has taken place concerning the measures introduced by Hungary. It is well known that Hungary has been accused, and the Hungarian government and the Hungarian prime minister quite concretely has been accused of trying to abuse the situation. And the statement made by the Secretary General of the Council of Europe, Madame Pejcinović-Burić, essentially highlights this in very unequivocal terms, I would say. And the criticism from all sides has been tremendous concerning the sort of the provisions of the relevant Hungarian legislation. So it is very much the fight against abuse, and it is very much about finding balance. And here, I think, and I will be slowly or rather more speedily already moving to the Ukrainian situation, because my time is running fast. Balance, I think, is one of the key words here, because there is always a necessity to find balance. Between the public interest and the personal autonomy of everyone. And human rights are, of course, about the personal autonomy, first and foremost. So the principle of proportionality would apply in any case, whether there is derogation or there is no derogation. And it is also clear that the obligations of the state, to protect the life and health of persons under its jurisdiction, they are also derived from the European Convention on Human Rights. And whatever measures are taken, let's say, to interfere with perhaps the right to, I don't know, to family, private and family life, or the freedom of assembly, and so on, these are measures that are actually caused by the obligation of the state to protect life. So these are positive obligations under Article 2 of the European Convention on Human Rights. So this is one thing. Secondly, again, derogation or no derogation, it is obvious that the European Convention on Human Rights will be checking the legality of the measures taken. So it will be checking whether the legislation adopted by the state concerned was accessible, and whether it was foreseeable. And this is something that the court would do anyway. Yeah? And it will do it certainly in respect of the 10 states that have actually taken such measures. Then again, the temporary nature of such measures is also something that needs to be taken into account. Whenever these measures are not required, they should be lifted. This means that they should be strictly limited in time. And this is also related to the other aspect of the field of application of such measures, which is the territorial scope. So if there are parts of the territory of a state where such measures are not required, then of course it would be logical to expect from a state not to resort to such measures in the parts that are not affected or less affected by the crisis. So these are the main parameters that will in any case be, I think, the subject of review of the European Court of Human Rights. However, there is one element with this review which needs to be taken into account. In most cases, I would imagine, of course, there could be extreme cases with the right to life, there could be cases that call for particular urgency, but in most cases, applications that might concern rights such as, let's say, the right to education or the right to the freedom of movement within the territory of the state and so on. These applications will probably not be prioritized by the European Court of Human Rights, will not be dealt with urgently. So the court will assess whether the measures taken were justified or not, whether we're compliant with the convention or not, in some 5 or 6 years. So essentially, the pandemic is here and now, and the review by the European Court of Human Rights is in 5 or 6 years. I think that this practical consideration is also something that has, to a significant degree, defined the response from various authorities. And now, if you allow me, if Olga allows me, very quickly about the measures taken in Ukraine and the current discussion existing in Ukraine. Ukraine has not introduced the state of emergency. And of course, had it introduced the state of emergency, most likely it would have also notified the Secretary General of the Council of Europe about the derogation. But it has not introduced a state of emergency. However, there is a similar legal regime in Ukraine, which is called the emergency situation. It's not really harmonized, and it's not very typical also for many other states, but this is what Ukraine has. So essentially, all the measures taken, they have been taken by the government, by the executive. This is something that is not very favorably seen sometimes, because the parliament should be involved, and the parliament at some point was involved and is involved still. It is not to say that everything is decided just by the government, but mostly these are government resolutions, starting with the so-called comprehensive lockdown, the comprehensive quarantine, and then gradually transformed in the so-called adaptive lockdown or adaptive quarantine. And this type of measures is, I would say, looks generally fairly balanced. However, interestingly enough, before the European Court of Human Rights will find time to deal with any applications that might originate from Ukraine concerning the currently taken measures, the Supreme Court of Ukraine, which doesn't have this of Ukraine, this official name, but it is the Supreme Court of Ukraine, it actually took measures on its own, and it challenged the measures taken by the government before the Constitutional Court of Ukraine. So one can expect that the Constitutional Court of Ukraine will rule on such issues. And exactly what were the concerns by the Supreme Court of Ukraine would be, I think, the shortest and the most concise and concentrated way to share with you the nature of the measures taken by the Ukrainian authorities. So the Supreme Court doubts that it was constitutional, and I must say that when it comes to constitutionality in Ukraine, the catalogue of human rights existing in the Ukrainian constitution is very much aligned with the European Convention on Human Rights. So it is really very much similar. So the first thing that the Supreme Court was concerned about was the procedure for self-isolation or mandatory observation of persons of the age above 60 years old that was imposed by the Ukrainian government. The Supreme Court says that it might violate actually the freedom of movement and also the principle of non-discrimination. Then the Supreme Court doubts the constitutionality of the prohibition for people to gather more than 10 persons at the same time. So this is the freedom of assembly that is invoked here by the Supreme Court. Then the lack of legal certainty in the measures taken by the government, they were rather obscure, at least as seen by the Supreme Court of Ukraine. Then it challenges the prohibition to operate for certain types of businesses, because it says that businesses should not be again discriminated and they should be free. Then the fact that hospitals, it was decided by the Ministry of Health that the non-urgent medical interventions should be postponed. This is challenged as something that it could be problematic from the point of view of the right to health. And then the Supreme Court says that the test applied by the ECHR is not actually would not be met by the measures taken by the Ukrainian government. Namely, necessity is not so much doubted, but proportionality and legitimacy is doubted by the Supreme Court of Ukraine, which says that actually the government should have introduced or should have initiated, because it's also the decision of the parliament, the state of emergency, and then of course this means that the derogation would be probably necessary. The Supreme Court also has other concerns concerning its own pay and so on, but these are less relevant things. So in a nutshell, measures taken by Ukraine demonstrate, on the one hand, the adherence to the principle of normalcy, so no immediate state of emergency, and at the same time, no notification to the European Court of Human Rights. It would seem, once again, something that I've already mentioned, I think, en passant today, that it is very much in the minds of the people in the government that they have to solve urgent issues, and the legal review will come later, and it is not really so important what will be the outcome. And this is rather deplorable because it demonstrates a certain possible lack of respect for the legal provisions and the rule of law. So this would be my initial intervention, and thank you very much for your patience. I'm sorry for exceeding the time limit. I'm looking forward to your presentations and also to the discussion. Thank you very much.
Thank you very much. Thank you for such engaging presentation. It was really interesting. Thank you for introduction to the topic and Ukrainian perspective. Unless there are any questions right now to Mykola Gnatovskyy, we will proceed. And the next speaker is Andrea Nikolić. She is consultant in the Ministry of Justice of Republic of Serbia. She is teaching at the University of Belgrade. Also, she is an ambassador for Serbia and Montenegro at Arbitration Intelligence Serbia. So, Andrea, the floor is yours.
Thank you so much. First of all, I would like to thank the Ukrainian Bar Association for organizing this event, and to thank you and you, Olga, personally for inviting me to speak at this webinar. I definitely agree that this topic is very much alive and that it will remain interested. Probably the main topic that everyone is interested nowadays is the ongoing pandemic, and probably the World Health Organization is one of the most popular organizations right now. And this crisis, as we just heard, will have a significant impact and has already have a significant impact on the way how we live, how we do businesses, on travels. Probably we all had some plans for the summer, but unfortunately everything is canceled. But also it will have a significant impact on how we perceive governments. And those long-term effects will clearly be the subjects of some other webinars or some other articles or dissertations. And in my speech, I will cover a few points. And actually, I'll just continue with addressing certain issues that were stated previously by my colleague. So first of all, I will tackle the issue and talk about the dilemma whether to derogate or not to derogate from the European Convention of Human Rights. What is the logic and the purpose of derogation? What is the required content of the notification? And of course, I'll address the case of Serbia. But first of all, I would just like to highlight once again that the European Convention on Human Rights is an international convention to protect human rights and also political freedoms in Europe. And it was drafted 70 years ago, but I think it's very useful to use European Convention as a benchmark, since it really can tell us what is acceptable and what is not acceptable in terms of human rights. And I think also that we can all agree that this corona pandemic caused a global crisis, and that we can all agree and that we can see actually that it is regulated in the convention itself, that states cannot just do whatever they want in order to respond to the crisis. However, there is the already cited Article 15 that allows countries to declare a state of an emergency in times of war or other public emergency threatening the life of the nation. And we also heard that so far there are 10 states, including Serbia and Latvia, that declared the state of emergency under Article 15. And also I would like to say that there are other states, like we also see Ukraine and other states like Italy. Excuse me, can you hear me, Olga? Okay, because I can see that Olga is talking. Okay, so there are other states like Italy and Spain, for example, that they have not used the mechanism under Article 15, but they have declared the states of an emergency in accordance with their constitutional provisions. And I will also address some potential reasons why they did so. We also said that according to Article 15, there are certain requirements that should be fulfilled. And the first requirement is that those derogations are permitted only in time of war and other public emergencies threatening the life of the nation. The second requirement is that those measures are only permissible to the extent required by the exigencies of the situation. And third, that those derogations must be consistent with these states' other obligation under international law. And one of the important principles of Article 15 is the principle of notification. So the notification and all the states that did declare derogation under this article, what they did, they sent an official letter to the Secretary General of the Council of Europe. And in that declaration, it should be stated what are the reasons and the justification of the measures and when such measures have ceased to operate. But going back to that dilemma, whether to derogate or not to derogate, I would just like to say that a lot of concerns have been raised, especially by some prime ministers, even by a spokesperson of the Council of Europe. And in my opinion, those concerns are understandable, given the dark history emergency power have from a human rights perspective. For example, some prime ministers are stating that if a state derogates from the European Convention of Human Rights, it sends a wrong signal about the state's commitment to the human rights. And it is considered to be, let's say, a damaging move, because usually countries with poor human rights record often declare a state of emergency, and for example, that's the case of Turkey. And this may be the key reason why some countries like Spain, Italy, UK have not declared the state of the emergency. But on the other hand, failing to declare the state of the emergency under Article 15 can also send a signal that is that the country is less accountable to the international treaties that it has signed. Another reason I have thought about this issue, and another reason, and what almost all countries that have declared the derogation under Article 15 have in common is that they are all or almost all former members of the Eastern Communist Bloc. And that status entailed that collective memory of human rights violations and a historically different approach of human rights, for example, collective prevailed upon individual, etc. So it does not take much to imagine that, for example, some restrictions of the free movement or restriction of the gatherings can be used to other ends, and that was actually the case in Hungary, for example. The president was actually the decree was proposed that the president will rule by decree with no cutoff date. Also in Serbia, we had a case that we had the provision on information allowing only prime minister and members of the crisis committee, crisis unit that was formed for a coronavirus crisis to declare and to announce all the news regarding the current pandemic. And the justification of the government was that it is preventing the spreading of the false news. So we have some indications on that already. And also the emergency powers have a worrying tendency to becoming permanent measures. If you start violating rights, for example, and the freedoms and the rights that are provided by the Convention of Human Rights, it is something that can very easily be extended to the entire legal system, to the local level, or even to the other levels of violation of citizens' rights. It's really then crucial that stakeholders, other people, NGOs can monitor and follow the situation and respond to it. Also, we also heard that the convention itself divides certain rights into derogable and non-derogable rights. And of course, the non-derogable rights are, we already heard, the right to life, etc. And Article 15 derogations will have and does not have absolutely no impact on those rights. But we also have some people argue that the impact of Article 15 will be very limited on other rights as well. Because we have some other rules and articles that allow limitation for a protection of health and public order, even without any emergency. So those limitations needs to be legal and proportionate, of course. But in my opinion, that's also a sign of respect for the Convention and the Council of Europe. And that Article 15 actually constitutes a different regime of legality rather than a zone of lawlessness. So this different regime can be used to quarantine the exceptional cases and the exceptional measures, and to definitely avoid the possible abuses of those measures. And then the logic of derogation is straightforward. I think that during the state of emergency, governments need the flexibility to react to the crisis. And if the COVID pandemic or any other crisis and situation, emergency situation requires exceptional measures and deviation from some dimensions of the full enjoyment of human rights, then it is the best to introduce those measures through a framework that will entail a commitment to legality and to the full restoration of normalcy as soon as possible. Also, regarding the content of the notification and the declaration itself, it definitely varies from country to country. Even the form varies from country to country, but in general, the derogation notifications are made in form of letters or notes verbal submitted to the Secretary of the General, and those notifications are typically deposited by political representatives of the states. In case of Serbia, that was the Ministry of Foreign Affairs that submitted the letter to the Secretary General. Regarding the content of the notification, it definitely varies across states. And for example, we can see that different states derogated from different provisions and different rights. For example, Latvia and North Macedonia derogated from their obligation under Article 8, then and 18. Then Moldova referred to Article 11 of the Convention, Article 2 of the Protocol, and Article 2 of the Protocol number 4, etc. But what we can see that definitely the first is the case of Serbia, Armenia, and Armenia that did not mention expressly what articles are affected by the derogation. Even some countries did not have even the annexes to the letter. But what I should say is that there is no prescribed form of the notification, and actually the mentioning of the specific convention article is neither required nor sufficient. So what is necessary is to definitely have sufficient information and to justify the reasons of those measures that are undertaken. For example, Serbia referred to the website of the government of the Republic Serbia, where all the legal acts are published and can be found on the website. What else I wanted to address briefly is that in Serbia we had the first reported case on 6th of March, and that the state of the emergency was declared on 15th of March. It was did in order to take measures to prevent the occurrence and the spread of the virus. Also, those measures were firstly, let's say, the recommendations, and then the mandatory measures that were referred to all citizens, to actually the whole territory of Serbia, not just the particular cities. So all the decisions were published at the websites. We had formed the crisis unit. Every day at 3 p.m. we had press conferences for the journalists to pose questions and to inform citizens about the current situation. What is also said in the note itself, and what should be highlighted, is that those measures that were undertaken, those measures have been constantly reviewed, taking into account the epidemiological situation, but also the recommendations from the World Health Organizations, the experiences, also the international experience and the internal experience that we had. In my opinion, I think that it's really like it's really a tight line, and we are slipping into the border of separation between what is allowed and what is not allowed. So in that sense, I and expressly actually acknowledging the exceptional and temporary nature of those measures that undertaken is the best practice, because it ensures that other states and the international human rights organization and other stakeholders, people, NGOs, can even monitor and police how those powers have been implemented. And with that, I'll conclude my presentation, and I'm looking forward to any questions or comments. Thank you.
Thank you, Andrea. Thank you, Andrea, for such an interesting presentation and bringing us up to speed what has been done in Serbia. In terms of that, so if we don't have questions right now, Victoria, I will check YouTube. But while doing that, I think that we can move to our speaker from Latvia. It is Ilze Dubava. She is lawyer at the State Chancellor of the Republic of Latvia, and she will bring us more details on what is going in Latvia on these topics. So, Ilze, the floor is yours.
Thank you, Olga, and thank you for organizers for inviting me to this, I must say, very, very timely and interesting discussion, and possibility to also share, but in a private capacity, my understanding on Latvia's reactions and reasons on derogations from certain human rights obligations. And in order to do that, I will first try to guide you through chronology of events as they happened in Latvia. And after that, I will address the reasoning behind the state, why it decided to derogate from certain obligations. And as to chronology of events, on 2nd of March, there was a first person who was confirmed COVID positive. On 11th of March, a World Health Organization went out with an announcement, and I would like to emphasize 4 elements in this announcement. First of all, that COVID was characterized as a pandemic. Secondly, there was a call for countries to take urgent and aggressive action. Thirdly, there was a call for states to detect, test, treat, isolate, trace, mobilize their people, in order to prevent clusters of the virus and of community transmissions. And finally, from the statement, I would also like to draw your attention that health organization also told countries that they must strike a fine balance between protecting health, minimizing economic and social disruptions, and also respecting human rights. Next day, on 12th of March, in line with domestic legislation, the government declared emergency situation in the entire territory of Latvia, and it was initially supposed to last until 14th of April. So for 1 month, it was subsequently extended twice and ended on 10th of June this year. The renewal for 1 month period was decided that it's better to renew in line with what is happening instead of having a longer period of state of emergency. And that was a famous, now notorious and famous cabinet decision, Order 103, that declared a state of emergency. And this declaration also put down the measures that the state chose in order to prevent further spread of COVID-19 disease. And the main measures were the following. And also what I must say that this time emphasis by state officials who were in charge of putting down these measures, that they really relied on and advice from epidemiologists. They were constantly present in advising the politicians on what kind of measures to take into account. And so the main measures which were effective from 12th of March were that all the state administration services that usually were provided in person were now provided remotely. Secondly, there were several restrictions on freedom of movement, like quarantine regime for those who came in from abroad and were coming in from states which were listed as kind of subject to high contamination levels of COVID-19. People and their contact persons were supposed to self-isolate at least for 2 weeks. There were travel restrictions. Latvia closed its airspace and also travel by train and ships and cars starting from 17th of March until 9th of May, except for cargo shipments and travels, and for specified repatriation flights, which were organized by Ministry of Foreign Affairs and Ministry of Transportation. And as of 15th of May, there was created, as regards the travel possibilities, what was called Baltic bubble, that because Baltic states had similar levels of people who got infected, recovery rates, then from 15th of May, it was allowed already to travel without restrictions within Baltic states, so in Latvia, Estonia, and Lithuania. Then next restrictions, which were put down by this cabinet order of 12th of March, were restrictions on gathering assemblies. And essentially it meant lockdown. There were severe restrictions on public and private gatherings, public events, rallies, religious events, and also on economic activity, like restrictions on bars and restaurants. And that was caused by a very limited amount of people who were allowed to be at the same place at the same time. Initially, that was only family members, like 2+1 or 2+2. Then there were also restrictions on access to education. That meant that there was a shutdown on on-site education process, and education was moved to remote studying process. The same happened with court hearings. All the on-site court hearings was moved to remote work mode. And there were limited rights to receive visitors in prisons, social care, and health institutions. And finally, on these main restrictions, but that's not an exhaustive list that I'm now putting forward, was also a limited access to health care services. And in accordance to the domestic legislation on emergency situation, next day, the parliament approved this order by the government. So internally, the power balance between legislature and executive was not dramatically affected. There was already measures in place how to act in the crisis situation, and then the executive is the one who takes quickly decisions, but there is still a need for parliamentarian approval. There were several other legislative amendments necessary and new laws. No need to mention them here, they are not relevant, but there were laws passed on continuous and effective operation of state institutions and authorities in this crisis situation, like for instance, how to ensure remote work of courts. And there was also legislation passed on support mechanisms for COVID-19. And what is also specific for military, early on in mid-March, one of the parliamentarians was also detected as COVID positive, and that meant that all the parliament and most of the cabinet of ministers and my colleagues from the state chancellery were sent in isolation. And the president, head of Supreme Court, chair of the Constitutional Court, and the Prime Minister, they gathered together in order to assess and interpret Constitution, in order to see the flexibility and kind of principles how for state to now operate in democratic manner remotely, and that was achieved, I would say, successfully. So that happened on the 12th of March. And let's say that this of 12th of March, which proclaimed state of emergency and put down the main measures, restriction measures, was till 9th of June, when it ended its effect, amended 23 times. And that indicates the extent of adjustments needed depending on how the situation developed and changed. On the 15th of March, emergency situation and measures taken to restrict spread of COVID-19 disease, in Latvia's opinion, necessitated notification of derogation under Article 15 and also under Article 4 of the International Covenant on Civil and Political Rights. And Latvia notified derogations from 4 human rights norms. Article 8 of the Convention, respect for private and family life. There was derogation notified under Article 11, that is freedom of assembly and association, as well as Article 2 protocol, that is right to education, and Article 2 protocol number 4, which is on freedom of movement. Already on 14th of April, that was government took decision to prolong for another month this emergency. There was another notification by the government of Latvia that eased the restrictions with respect to freedom of assembly. That's Article 11 of the convention. And that notified that there is an ease and already withdrawal of this derogation from conventional norm, because it was already by that time allowed for up to 25 people to gather in public places, subject to several restrictions, like that there must be 2-meter distance ensured by organizers and people, and that they need to comply with epidemiological safety rules. There should be disinfectants available, and if events happen indoors, they should not extend more than to 3 hours. Another ease of the derogations that were notified by Latvia were already notified on 14th of May, that time when the government decided to prolong for another month's emergency situation. In this next notification, Latvia eased and withdrew announced limitation on right to education, because as of 1st of June, education process was not anymore conducted remotely, also because school year was most over, except for exams for those who graduated high school at that time. And that the state already made a decision that students will be allowed, those who were obliged to take exams to graduate from a high school, that they are allowed to pass exams in person. There was on 2nd of June already state withdrew its derogation from right to education. And the last pronounced potential derogations from human rights, so respect to private life and freedom of movement, ceased to exist on 10th of June. That was also the day this emergency ceased to exist in Latvia. So that's about the chronology of events. And knowing this, I think it will be easy. Latvia decided to ratify derogation in with Article 15 of the Convention and for of the COVID. Yes, it was already mentioned by the previous speakers that there were in total 10 states, and there is some geographical kind of potentially linkage of those states who notified derogation, but there is also San Marino or North Macedonia. So Serbia, Romania, Armenia, Moldova, Estonia, Georgia, and Albania. All the states which decided to notify derogations. And there are two doctrines already nicely touched upon by Mykola on whether to notify derogation or not. And the theory number one would be on necessity and desirability, saying that it is necessary in these emergent situations to notify derogations because internal of these human rights obligations is paragraph 2 of the respective norm intention is not flexible enough, and they do not accommodate these emergent measures. And these measures are far-reaching, and this situation is out of normal. And if these measures would be considered as still fitting in the traditional scope of allowed limitations, that would mean that the limitations and restrictions would be allowed to be interpreted in extensive ground, and that is threat to the human right protection in general. So that is a call, like this doctrine stands behind the slogan, exceptional powers to exceptional situations. And there is no need to mess with the traditional application of restrictions in situations where it is permitted by the convention. Another school is to say quite the opposite, that there is subflex those right norms is able to accommodate with these restrictive measures put forward by most of the states who are members of European Court of Convention on Human Rights. And derogation in times of emergency is particularly unwelcome because it kind of allows states to escape accountability in times when accountability is especially needed. There are crisis measurements and there is more power given to executive powers. Latvia's approach was to follow the doctrine number one. And there is also like a very technical reason for that, basically understanding that the traditional limits of these human rights norms from which Latvia notified derogation are not flexible enough to be read in these specific measures that were taken by the state. That also Latvia's decision to notify was based on these very specific measures that the state decided to take in order to tackle the spread of COVID-19 disease. And the Office of Representative of Latvia before international human rights organizations notified derogations on the basis that ordinary limitations because proportionality assessment of the measures might not be met. And going back to the traditional way how proportionality measure is assessed, it is part of decision on like legal restriction, which should be based on law, should achieve legitimate purpose, and also be necessary in democratic society. And that necessity assessment also includes individual assessment, how this measure impacts individual cases, whether that is a proportional restriction. And that was Latvia's decision that this individual assessment might be problematic in the situation. And that's why Latvia opted for this understanding that internal flexibility of human rights norms in order to impose not met. And thus derogation opinion was necessary in order to maintain legality of law in time of emergency. And secondly, Latvia's commitment to legality and normalcy. And it was also a sign of precaution. And however, despite the fact that derogation was notified, Ombudsman, which is one of the institutions that in Latvia that follows human rights compliance and has a lot of powers to counterbalance acts by other state institutions, agreed with the state that the integral flexibility of these human rights norms that were addressed in derogation notification, it's not enough. And that Article 15 has a criteria strict enough for state, if it complies with them, not to go over its powers under this Article 15, and still the constitutional complaints mechanisms and the European Court of Human Rights is still accessible to individuals for ex post assessment of legitimacy of those measures. And that's why the derogations were kept under review, and that these measures were exceptional and temporarily really limited in time, and that was acceptable. So that's a broad overview on the reasoning by state, why it derogated and from which norms it decided to derogate, like notified derogation. Thank you for your attention.
Thank you, Ilse. Unfortunately, I had to change my position from here, but I have listened to the entire presentation. Thank you very much for bringing us more details on how Latvia decided to deal with Corona situation and with convention derogations. So, Victoria, please advise whether we have any questions in the chat or on our YouTube. No. Till now we don't have questions, but I actually have a question to our speakers. Actually, this question is to Mykola Gnatovskyy. Mykola, what do you think, based on the input from Serbia and Latvia, whether Ukraine could have accepted some steps from these countries' experience, or restrictions that Ukraine has taken were absolutely not necessary to be covered by derogations of the convention?
Yes, thank you, Olga. I appreciate your commitment to this event, despite the exigencies of your situation. It was very interesting to listen to Andrea and to Ilse, and thank you very much for your excellent presentations. And really, I learned a lot from what you've said concerning the measures taken in Serbia and in Latvia. And answering Olga's question, you see, I personally tend to agree with those colleagues who say that derogation per se was not an absolutely necessary move for Ukraine. So I tend to accept the decision not to make this derogation. However, and this is very important to underline, whether there is a derogation or no derogation, and this is, I think, also that is quite clear from the presentations that we had today from Andrea and from Ilse. It is obvious that the compliance with the European Convention on Human Rights, with other applicable human rights instruments such as the International Covenant for Civil and Political Rights and so on, that they will be assessed based on what the states actually did. So the sending a notification of derogation might, of course, change a little bit the way that this would be approached by the respective convention bodies, and in the case of ECHR, of course, by the court in Strasbourg. But I don't think that this change would be so drastic. The most important thing is that the measures taken in any case had to comply with the key requirements that were mentioned, I think, by all the speakers today, namely that they were based on the imperative public interest, and they took into account the individual human rights of everyone concerned, that they were legal, necessary, that they were proportionate, and that they were limited in time. If that is respected, then I don't think there will be a major issue with the review of these measures under the Convention, on the European Convention on Human Rights. I would not exclude that certain individual measures might be questioned and might be actually successfully questioned. But again, the situations in various countries are very different, and also one needs to keep in mind the constitutional framework of every country, because it is, at the end of the day, it really depends on the national constitution. What is the exact procedure for example, for declaring the state of emergency, and what are the measures that can be taken there? So that would be my answer. I think that this is very important, and this experience is certainly useful for Ukraine, but I don't think that it necessarily means that Ukraine should have done something differently. Again, as they say, the devil is in the detail, and the detail is very multifaceted. So we'll see in a short while. Thank you.
Okay, thank you very much. It was really interesting for me, because I was not that up to speed in this topic, and I think that all our participants also appreciate these comments. So, Andrea, Ilse, Mykola, do you have any questions to each other? Maybe you want to discuss some hot topics on that in the format of panel discussion?
If I may, I wanted to ask Ilse whether she has an opinion, because I was intrigued by one of the measures introduced by the Latvian government, and you know that I'm dealing with the rights of persons deprived of their liberty in my practical work, and the derogation to the Article 5 was mentioned in the Latvian derogation, as far as I understand. No, am I mistaken? No. Okay, because then I think I misread something, because there was something about the possibility for prisoners to stay a bit longer in the prisons because of the COVID-related measures, or was it a misunderstanding? Because I was a bit surprised. Probably I misunderstood something.
There was limitation on prisoners to accept visitors, but there was nothing. Article 5 was not notified.
Okay,
at
thank
least
you.
not on official. Yeah.
Okay, I'm sorry. Then it makes perfect sense, because the limitation of visits is something that prisoners have experienced all over Europe, and this is normal, and the important part again is that such restrictions should be lifted once they are no longer necessary. But yeah, that is perfectly fine, legitimate. Thank you, Ilse. Thank you for clarifying this. I was misinformed, and thank you.
Okay, are there any other questions from Ilse or Andrea? Maybe you're interested in some Ukrainian experience or what have you?
I do have one question. So do we understand the case what Supreme Court brought to Constitutional Court is still ongoing? When it's expected that there will be a decision on that? And if there will be a negative decision, what will happen?
Yes, thank you very much, Ilse. Well, the questions are very clear. With the Constitutional Court of Ukraine, essentially, we do not know, because when they're going to deliver their judgment on this particular question. The problem is with the Constitutional Court is that they are not limited in time in any case, so they can do what they can keep it long, or they can do something rather quickly. some of the most high-profile cases in the Constitutional Court of Ukraine, such as, for example, the constitutionality of the laws on vetting, the so-called lustration of officials who worked in the government before 2014. The Constitutional Court has held it for years on end. It actually has waited until the ECHR ruled on the subject. And because, well, one can understand, of course, there are very politically sensitive issues there. But here, I assume it shouldn't be so long. So I would expect the judgment to come within a year or so. But again, this is just speculation. I can't be sure. Regarding the practical implications, that's an interesting question. I think the immediate effect would be, of course, that the resolutions of the government, which might be still effective when the Constitutional Court comes up with their judgment, if of course it agrees with the Supreme Court, which is not to be taken for granted, then those resolutions will be invalidated wholly or maybe in part. So this is one immediate thing. But again, depending on when they're going to do it, because if they naturally expire and the pandemic is no longer there, let's hope, then of course it wouldn't be so important. Then there will be an immediate consequence concerning the pay, because one of the issues they're raising in their application to the Constitutional Court is actually the decision to freeze the payment of salaries to judges and to also to make them smaller. So of course that if that would be declared unconstitutional, it would mean that, well, the money will have to be paid to the judges. But there might be some also retroactive effect, because then if certain things were to be found as not compliant with the Constitution, then persons affected might bring their individual action on the basis of this. Again, that requires a bit of imagination to really speak about these things. I assume it shouldn't be so dramatic. As Minister of Justice of Ukraine once said, if the court finds any of the coronavirus-related measures of the government invalid, so be it. We will then introduce other measures.
Okay, thank you very much, Mykola. So, are there any other questions from the audience or speakers to each other? If not, then I think we can wrap up. Thank you everyone for joining and for making this discussion really interesting, detailed, with legal details and quite effective in time. It is really important for such kind of events. Ukrainian Bar Association and International Law Committee thanks everyone for joining. After the event, we will share links today or tomorrow to this event to speakers' emails, and also we will share it on our Facebook pages. So everyone are more than welcome to comment on that. And thank you very much for joining. Thank you for your time, and it was really valuable and interesting presentation.
Thank you very much, Olga, and thanks for everyone. Thanks to the committee for this initiative, and thanks to the speakers. It's been an honor and a pleasure to participate. Thank you.
Thank you.
Thank you.
Thank you. Bye.